Elections in Nigeria, how could we move forward? What is your assessment of all the electoral jurisprudence, and should we go back to reform our electoral laws?
Charles, we have the largest number of election cases in the world, the largest number of election petitions, and the largest number of pre-election cases, because the members of the political class are not prepared to allow democracy to thrive in Nigeria. So what they do is to try and rig and out-trick themselves. And at the end of the day, the problems are then thrown at the courts and election petition tribunals. You need to appreciate the danger that we are facing. Right now, majority of cases in our court, many of our courts, are simply suspended to allow for time-bound election disputes to be resolved. We can't go on like this. We just cannot go on like this. And what is the solution? Again, once the ongoing election petitions are concluded, we must, in the interest of the country, go back to the drawing board. And the solutions are around the corner. But successive regimes, since about 2007, have refused to adopt the solutions that have been preferred. The first one is on the independence of the management election bodies, the INEC and the State Independent Electoral Commission, which, by the way, the State Independent Electoral Commission conduct the worst elections in Africa, whereby all the candidates of the ruling party must win. 2, some of those who are accusing INEC of rigging elections perform worse in the conduct of primaries of their political parties. Now, the first one is we must have an electoral body, and we're all going to respect that is independent and well-funded. One, the Ways Electoral Reform Panel recognize that when the sitting president appoints electoral chiefs, there are problems. Therefore, we're going to appoint electoral chiefs, INEC chairman, the commissioners, national commissioners, and the RECs, resident electoral commissioners, by advertisement.
But that's been talked about before. I remember you talking about it in 2019.
Yeah, but these guys are not ready.
Right.
Now, once that is done, the National Judicial Council will shortlist and send the names of the best 3 for each of the positions to the Senate. The Senate that will screen them, not take a bow, re-screen it to know if they are competent. Right. Secondly, all election petitions, all disputes shall be concluded before the inauguration of the incoming government, so that nobody will be accused of using the position of the executive incumbency powers while your election is still being disputed.
But do you trust the judiciary to be able to really deal with those cases in that short space of time?
Well, we have 6 months.
Yeah, because you see I see what you mean. Yeah, since from the conclusion of the election
let me just finish.
Right.
Yeah. The third one is that the onus of proof, the onus of proving that a credible election has been conducted shall be on the INEC. Because you have told the whole world you have conducted the best election. You come to court and prove same. Because to impose the onus on the petitioners is very difficult. To get the election materials, a Herculean task. But INEC has all the materials. You come to court and prove that the election that we have spent huge sums of money on has been well conducted. So these are the major recommendations.
But what is the state of the law at the moment? Can someone, because you, for example, in the past, you've had the reputation of taking different institutions of government to court.
Yes.
I mean, can someone take INEC to court and say, come and prove just what you said, that you conducted a free and fair election?
Under the current Electoral Act.
Right.
The onus is on the petitioner. But the Ways panel recommended that the onus be shifted to INEC. I mean, for instance...
But can you do it as a civil case and
no,
say, right,
because the law is there.
Right.
And this is what the law has provided for. Yeah, and so that is why the commission, the panel recommended that we need to amend the Electoral Act. And since then, we filed the Electoral Act 2010, Electoral Act 2022. And these guys simply brush aside this fundamental, amendment, recommendations. Because in 2011, there was a crisis following the announcement of the result of the election. There were protests in about 12 states in the north and in Akwa Ibom state. And on that basis, President Jonathan set up the Ahmed Lemu Committee to review the crisis and then make recommendations. Again, the panel came to the conclusion that for us to avoid electoral violence and so on and so forth, we need to go back to Waste panel. President Buhari, who was elected in 2015 and celebrated the introduction of technology, also set up a panel headed by Senator Ken Naman to review our electoral law. Again, that body recommended that we need to go back to Waste panel. So there is a general understanding that we need, incidentally, as the national leader of the APC, I think, yes? No, ACN, then APC. Asiwaju Bola Tinubu, the current president, set up a committee, CODA, Committee to Promote Electoral Reforms. And that body also campaigned for the implementation of the recommendations of Waste panel. So there's a general agreement that we need to reform the electoral law instead of blaming judges. The current Electoral Act and the jurisprudence promote injustice. For instance, in the Electoral Act, paragraph 51 of the fourth schedule told the electoral provides that no electoral officer can go to court or the tribunal to give evidence against the election that has been conducted, even if he or she is convinced that the election has been manipulated, unless he obtains the fiat of the Attorney General. The Attorney General, either at the federal level or the state level, is likely to have been appointed by the president or the governor, whose election is being disputed. So, and the other point that was made, that the era of the impunity that characterizes our elections has to stop. And so the panel again, the Waste panel recommended the establishment of an electoral offences tribunal. We pursued that matter 2 years ago, or last year. We convinced the Senate to pass the bill for the establishment of an electoral offences tribunal to deal with those who are messing up the electoral process before, during, and after the elections. Again, the House of Reps did not pass the bill. Hence, we are back to square one. So again, this is an opportunity now for us to look at the aspect of the Waste panel's recommendations that have not been implemented. So that we can put an end to this ugly development and the shame.
That's a very good point. Yeah. But in that context, should those electoral reforms be spearheaded by President Tinubu himself? Is that the way to restore confidence?
No, as I said, President Yaradua in 2007 admitted publicly that my election was highly flawed. That's Islam way. Therefore, I'm going to ensure that we do not have a repeat. I mean, that was General Obasanjo's election, the do or die election, which over 300 people were killed. And before that, 2003, Buhari and Obasanjo, the late Justice Pats Asholonu made the point in the Supreme Court that under our electoral system, to successfully challenge a presidential election, you will need about 250,000 to 300,000 witnesses. And there can be no time for that. Now, we have only 21 days to do that. Now, what then happened after that? The panel made profound recommendations. Even the Yar'Adua regime did not quite accept.
So clearly, this is much more political than legal.
Of course.
Really.
Now, as I said, President Jonathan set up a panel, President Buhari set up a panel. Now, President Tinubu will have to lead the campaign. Now, it's very, very, very important. And that is the only way for us to get out of this mess. It's a monumental mess. The waste is unimaginable. The enormous cost to the society, the damage done to the reputation of our courts. It has to be, we have to look at all these implications and then insist that just like Kenya in 2017, I compared the electoral process in Kenya and Nigeria following the annulment of the presidential election in that country. And I came to the irresistible conclusion that we cannot continue like this. Happily, those who have just lost elections now are now asking for the Kenyan model. So we have to, just like Kenya decided, we cannot continue like this. Nigeria has also got to that stage. Because we are 300 billion naira for the election.
But does it really matter how much you rewrite or reform the Electoral Act? I mean, because in the final analysis, some would argue that it's just a piece of paper unless the law is applied and enforced. So shouldn't the focus be on reforming the institutions?
No, you're going to reform the institutions by reforming the law. For instance,
yeah, but they've reformed the law, but the institutions haven't moved on, have they?
Reform the law.
I mean, the Electoral Act, 2022 Electoral Act was supposed to be a reform.
For instance, I can tell you.
Right.
In the 2010 Electoral Act, Section 34, gave every citizen the local standard to challenge the information provided by any candidate. So, but these guys removed that section and then amended the constitution to declare that only members of a political party can challenge the nomination, the disqualification, or the sponsorship of a candidate. Now, instead of looking at the law, we're blaming judges for interpreting the law as it is and not as it ought to be. So that is why the law is so fundamental. Once we have reformed the law, and we set in place the Electoral Offences Tribunal, then we can deal with those who manage the institutions dubiously or criminally, and individuals who also commit electoral offenses right now. And this was again another recommendation that INEC has to be unbundled. INEC currently will have to register political parties, will have to register voters, will have to conduct elections, will have to monitor the political parties, will have to examine their finances and so on and so forth. Hence, the Ways panel recommended that INEC be unbundled. Right now, it is even INEC that is asked by the, I think, Section 145 for the current Electoral Act to prosecute electoral offenders. INEC does not have the means to do that. Hence, the Nigerian Bar Association is trying to work with INEC on a voluntary basis to prosecute some electoral offenders. But that shouldn't be so. The Ways panel discovered that we're dealing with gross impunity, and therefore recommended that there should be a body. If we want to get our Electoral Act respected by all and sundry, we need a body to arrest violators of the Electoral Act and then have them prosecuted, so that some lessons will be learned. But right now, all those who were arrested the last time, including somebody I think in Rivers, who was caught with about $500,000, the case filed against him and been withdrawn by the Rivers State government. And that is the whole purpose of saying, let us have an independent body to deal with electoral offenders. And once you don't sanction criminal elements in a society, there's no way the institutions will work. I mean, look at what is going on in the US.
It sounds like
President Trump is facing a standing trial in 4 different courts. It's impossible here. The big men and women here are above the law, And so we must go back to the society
that speaks to institutional reform.
Of course,
yeah.
Of course. And like I said, we must reform the law and reform the institutions. But what is important is to punish offenders.
But you see, all these things you've said, and you have consistently said over the years. I mean, your position has not wavered.
No.
Clearly, it sounds like it's the best way to advance the course of democracy in Nigeria. And every time you recommend going back to the drawing board. But how do you push that point to the relevant
what we are doing
institutions
now,
like the National Assembly?
At the level of the civil society, we have Alliance on Surviving COVID-19 and beyond. We have other organizations that have been mobilized to insist on major reforms of the electoral laws. And unless we do that, and the campaign is starting soon. The campaign is starting soon. And some of us are going to invest in that campaign in the interest of all of us. I mean, you have young people who were voting for the first time and they felt so disappointed. And we can't go on like that. We cannot go on like that.
Absolutely.
Because once people are frustrated from believing in the electoral system, they begin to look for very dangerous alternatives, and which is not in the interest of democracy.
Yeah, you make some very good points there, but it's not every day we have you in the studio, Mr. Falana. So I'd like to get your thoughts. Just move slightly, still election related. We'll kind of move slightly away from these reforms that you're talking about to an issue that's in the news right now, which is, you talked about the United States, a judge there adjourning Chicago State University case, President Tinubu's case, till Monday, and temporal stay of execution after Tinubu's plea that it'll cause irreparable harm to him. Give us your take on that. What kind of irreparable harm could it possibly, what are they talking about?
Charles, I think that question should be directed to the president's
I understand that.
But what is important, frankly speaking, again, this is part of the problem. We conduct an election in other African countries, right? You only go to the Supreme Court or the Constitutional Court, and these matters are decided within 14 days. In our own case, the presidential election dispute will be in 2 courts for 8 months. Governorship will be in court, 3 courts for 10 months. It doesn't happen anywhere in the world. So we must learn, draw some lessons from this crisis.
I understand the way you're parrying away that question.
Election petition going on in Nigerian courts and the United States.
Right. But let me ask you this.
Like I've told you.
Yeah.
I'm not in a position.
No, I understand that, and I'm not trying to put you in a straight jacket. Right.
I'm learning from the U.S. system.
Right.
Is the speed.
Yeah, but let me ask you this. There seem to be many people who believe that there is a desperation by the president to hide those records from Chicago State University, and that ultimately it could prove to be a huge embarrassment for Nigeria because of that. What are your thoughts on that?
Charles, as a lawyer, I deal with evidence. You're a journalist, you can engage in speculation or conjecture. But based on the facts on ground, in the United States, everybody has the right to plead privacy.
Yeah, I understand that.
Now, the university, right, even in the secondary school in the US, in the college, to release sometimes the result of a student, even to the parent, there are laws guiding them. So if the president says, sorry, I don't want my result, my details released, right? The court will have to consider the implication of that on Monday. Vis-a-vis the request by
Yes.
Mr. Atiku Abubakar to have those results.
Yeah,
so
but
that's for the judge.
I understand that, and I understand the
in other words, the private
clauses.
interest of the president will have to be considered.
Yeah.
Right.
Yeah.
With President Atiku.
I understand that, but as a lawyer yourself, which you've emphasized the fact that you are a lawyer, what would have prompted you to, on behalf of a client in such circumstances, to hurriedly appeal against the judgment of the magistrate court ordering the release of just academic records?
No. Again, the university has said President Tinubu attended this system. The management of the school has said he attended the school. Mr. Atiku Abubakar is insisting I need the record because there's a case going on in the Supreme Court. Now, again, it depends on the privacy, the right of the student.
I understand that.
To have his relief.
But it's also interesting, isn't it, from a legal point of view, that there's another complication, which is that the university are saying that, as you said, he attended the school, but they are not willing to say that under oath.
Yeah. Again, what
does that tell you?
That is the problem of the school. Again, I think we should wait till Monday.
Right. Okay.
The court will have to take a decision.
Yeah, but let me. I understand that. Let me get you to wear not your legal hat, but your civil rights hat, for which you're well known and you're well respected. You're an activist. Would you call on Nigerians to demand from the president that he release his authentic academic records and clear the air once and for all? In other words, as some have suggested, it should not be a fight for Atiku Abubakar alone. It should be a fight for Nigerians to demand to see the records of their president, given that it's so controversial.
As far as I'm concerned, right? Nigerians, right? Majority of Nigerians, and I'm not talking of the elite, are busy trying to eke out a living, right? But if you are talking of a public figure, right?
Which he is, clearly.
You hardly have private lives, private interests. But if under the United States law, somebody says, I don't want my results, details of my results released, you then leave the terrain of law to the area of morality. Should they have released the result? Should they have allowed the university to release the result or not? Now, and the court on Monday will also look at the totality, the implications, and also the court will also want to know what is this request about. And the court in America will then balance the interest. Should we compel the university to release the result in spite of the objection of President Tinubu or not? Or The university says we're not ready to be deported. Again, that is the business of the university. Right? But that is not for a Nigerian lawyer to insist.
No, I understand.
Forget your law in America, respond to the demand of Nigerians.
I totally understand
so
that.
That is the position of the law. Because at the end of the day, another battle will arise. Even here. Even if the records are made available, there's another issue here, which is, can the record be admitted?
Yeah, that's an important question.
It's an unfold, for me, it's an unfolding
and that's a question that you can't answer.
No, I can't.
That Atiku has filed his case in the Supreme Court.
Ethically, I cannot preempt the Supreme Court.
Obviously you can't preempt that. But is it your sense, based on what you know of the law and the time frame and all the rest of it, that Atiku can submit whatever emerges as fresh evidence in the Supreme Court, or is that not going to happen?
Frankly speaking, I don't want to express an opinion on that.
Right.
Frankly speaking. Because again, I would be preempting the Supreme Court. And I don't want to do that.
Right.
And in fact, the application has not been made yet.
Right. Okay.
Yeah. So it won't be fair to turn your phone.
I understand that. I understand that.
Yeah.
On that note, I want to say thank you very much indeed.